Okay. Thank you for giving us the opportunity to report our research on a comparative legal study of data breaches. This is a list of contents. My name is Kaori Ishii. I am an associate professor at the University of Tsukuba, and my co-presenter is sitting there, Mr. Professor Taro Komukai in Nihon University. In this presentation, we focus on the liabilities and duties of data controllers regarding data leaks and compare the relevant legal schemes of Japan, the US, and the UK. Once a data breach occurs, the leaked data can instantly be circulated all over the world. Establishing common rules among countries is therefore the ideal. However, there are many differences in the circumstances of particular data breaches and the legal approaches for addressing them. Recognizing the existence of differences can provide us with valuable suggestions for realizing appropriate measures. There are three primary approaches to the issues concerning data leaks. The first, providing remedies for data leaks. Second, data security obligations. And the third, notification obligations in the event of data breach. This slide shows the legal remedies for data leaks in Japan. Claiming damages for data leakage is based on tort law from the Civil Code, and the Act on the Protection of Personal Information requires data security. Moreover, the Japanese cabinet recommends a type of data breach notification. The Act requires data security for businesses handling personal data. Failure to comply with the Act may result in administrative enforcements such as recommendations or orders. If a company does not comply with an order by a competent minister, it will be subject to a criminal offense. Excuse me. Thus far, the practices of competent authorities are quite reserved. However, in Japanese culture, companies confront severe condemnation from the general public and mass media regarding their data leaks. For fear of losing consumers' trust, companies are usually eager to maintain security measures regardless of the existence of legal obligations. This is a summary of main data leakage court cases in Japan. Courts have found organizations that have carelessly or deliberately leaked personal data to be liable, as shown in this figure. However, even if an injured party files a suit against a perpetrator, the plaintiff often gets only a small amount of money for damages arising from emotional harm. A recent noteworthy case in 2014 involved the Benesse Corporation. A giant education company, Benesse, leaked approximately 29 million pieces of customer data, including children data. One of the employees of the subcontractor allegedly copied the data list from the firm's database and sold it to 3 data brokers. The data brokers resold the data to other brokers. Finally, the competitors of Benesse bought the data. As of today, 2016, over 10,000 people have sued Benesse, claiming damages of 55,000 yen, about 400 pounds each. The Act was amended to introduce the obligations for keeping data transaction records and other obligations triggered by the Benesse case. This table shows the number of published data leaks under the Cabinet policies on the protection of personal information. Concerning data breach notifications, the Act does not have any provisions so far. Instead, the Cabinet policies concerning the protection of personal information put forth by the Japanese Cabinet stated the need for data breach notifications. Many companies disclose information regarding data leaks, even if most of them are small cases caused by carelessness on the part of workers. And recently, so-called National ID Act was amended to introduce the data breach notification obligations to the Personal Information Protection Commission. Personal Information Protection Commission is an independent supervisory authority like Information Commissioner in the UK. This is a progress in Japan. This slide shows the legal scheme of remedies for data leaks in the US. The US provides all these measures as formal legal schemes. This table summarizes the cases involving massive data leaks caused by hacking in the last 5 years. The distinguishing feature in the US is that class actions have been brought against the companies involved, and many cases have been resolved by consent judgments. The FTC has also played an important role in data breach cases. Article 5 of the FTC Act declares that unfair or deceptive acts or practices in or affecting commerce are unlawful. The FTC has the authority to investigate and initiate an enforcement action against a company in violations of the FTC Act, and recently has actively exercised enforcement actions against data breach cases that are mainly solved by consent agreements. The first state to pass legislation requiring data breach notification was California. The California Security Breach Notification Act requires a business or state agency to notify any California resident whose unencrypted personal information was acquired by an unauthorized person. According to the California Data Breach Report of 2016 that updated the 2014 report, more than half of breaches were the result of malware or hacking, the intentional unauthorized intrusion into computer systems by outsiders. The report emphasizes the importance of learning from these cases and improving security measures such as encryption, tokenization, solutions, and so on. This slide shows the legal schemes in the UK. The first, Article 13 of the Data Protection Act 1998, provides data subjects with the right to receive compensation for any violations by a data controller. The second, the provisions of the Data Protection Act are applied to many security breach incidents. Schedule 1 of the Act prescribes 7 data protection principles that data controllers must follow. The first principle states that personal data shall be processed fairly and lawfully, and the seventh principle requires that appropriate technical and organizational measures be taken to keep personal data secure. The Information Commissioner is able to impose monetary penalties not exceeding £500,000 against data controllers who have violated data protection principles. The third, the Act has a unique article that makes it unlawful to obtain or disclosure of personal data and ends up with criminal sanctions. Also, confiscation orders might to be imposed with criminal sanctions. The fourth, the Data Protection Act has no provision for the data breach notification, but the new General Data Protection Regulation has the provision. General Data Protection Regulation in the EU has the provision of the data breach notification. In addition, the UK has the Privacy and Electronic Communication Regulations of 2003 for telecommunications providers. They are required to notify the Information Commissioner's Office if a personal data breach occurs within 24 hours, becoming aware of the essential facts of the breach. I have heard that an expert at the ICO said that the introduction of a rule for data breach notification in all sectors would make data flow clearer and would provide greater opportunities for enforcement. The transparency of data circulation is implied in the first principle of the Data Protection Act. Although the UK made a big decision to withdraw from the EU, drastic changes are not expected in the field of data protection. However, we should keep an eye on the changes that occur with the implementation of the General Data Protection Regulation in the EU in 2018. Based on the ICO's information, the graph shows the trends regarding incidents in relation to data security from April to June of 2015. The majority of data leakage occur in the public sector. The ICO reports that the health sector continues to account for most data security incidents. And a few days ago, TalkTalk was imposed monetary penalty by the ICO for £1,000 due to the breach of privacy and electronic communications regulations. This table also summarizes the main data leakage cases that occurred in the UK between 2007 and 2015. Although the scale of the leakage is not as large as that in the US, the Commissioner imposed penalties on the perpetrators in some cases. Okay.
Okay, I would like to go into the discussion part. Getting back to the three approaches we mentioned first. And all three countries have some measures of three approaches, And of course, the surroundings of the data breaches and the issues within each country are different, of course. Okay, let me sum up these approaches in three countries. I mean that I would like to summarize and review it. First, compensation. In Japan, most data leaks are made by employees or subcontractors who disclose a small number of records. Business operators have had to pay compensation in relatively small amounts thus far because secondary harm, such as identity theft and fraud, have been outside the scope of consideration by court. In the US, hacking and malware issues are common causes of data leaks, and economic damages are crucial to this issue. There are many class actions seeking compensation for data leaks, and amounts are generally high. In the UK, There are not as many leaks as in the US, and class actions against data leaks seems to be rare. Rather than claiming compensation by individuals, such cases seem to have been dealt with by enforcements issued by the ICO. Okay, second, the data security obligations. In Japan, for fear of losing consumers' trust, companies tend to eagerly maintain security measures, regardless of the existence of legal obligations. Such security measures are not effective for other companies that do not care about their reputation as much. That is a problem. In the US, the FTC has rich enforcement experiences in accusing enterprises of lack of security measures based on Article 5 of the FTC Act. The FTC's role in this rigor seems to have been effective. In the UK, although there have not been massive data leakages on the scale of those in the US, the ICO has compiled a list of enforcement cases. In addition, the Data Protection Act stipulates criminal sanctions against the unlawful acquisition of personal data. Along with the sanctions, confiscation orders seem to be effective in reducing illegal data transactions. We have to learn about this. Third, data breach notifications. In the US, notification obligations apparently have proven effective in responding to the unlawful use of breached data. In Japan, companies tend to follow the breach notification rule, even if it is just a recommendation, not binding. We have to say that the practice of data breach notification in Japan seems to have lost substance because of the number of notifications that have been submitted, including small cases, and there has been little enforcement or countermeasures taken based on these notifications. In the UK, the breach notification was introduced as a sector-based rule in the Privacy and Electronic Communications Regulations of 2003. As the GDPR is formally adopted, the scope of the rule will be expanded generally. The ICO views this positively, as it is expected that the rules will improve the transparency of data circulation. Okay, the slide shows the possible data flow and legal schemes for addressing data breaches. Some intruders sell the breached data to data brokers, and others provide the data for criminal offenses, such as fraud and other property crimes. This side is criminal, and this side is seems to be data brokers. Yeah. In relation to compensation, the economic damage easily lead to a higher amount of compensation than the damages arising from emotional harm. The data security obligation is expected to reduce the risk of both sides circulation of personal data and economic damage. Data breach notifications are essential to reduce the secondary harm resulting from the criminal use of leaked data. However, as breach notifications only alert data subjects of the fact of data circulation, they need to be followed by further measures to effectively reduce the secondary harmful use of personal data that would lead to economic damages. Okay, this is the last slide. We can say that data leaks cause two types of issues. One is a privacy risk caused by the wide circulation of personal data, and the other is the risk of economic damage. The legal schemes in Japan and the UK place more importance on risk caused by wide circulation than on economic damage, whereas the US is the opposite. The data security obligation is obviously effective for reducing both risks. On the other hand, compensation and data breach notifications are somewhat more effective against the risk of economic damage than against wide circulation of personal data. To reduce the risk of wide circulation of data, an obligation to maintain data traceability would be preferable. In terms of data breach notification, we had to emphasize two further measures for effective management. The first is the need to use the reports for reducing the secondary harm. The information about the data breach should be shared among credit card companies, for example, in order to prevent the criminal use of leaked data. In that case, the Data Protection Authority should positively provide the information about the data breach to relevant companies. We have to acknowledge that the information on breach notification has not been effectively deployed so far in Japan. The second is effective enforcement activities on the side of the data protection authorities. On the one hand, the Data Protection Authority needs to encourage breach notifications by not imposing adverse effects or sanctions against honest data controllers. Needless to say, the enforcement on negligence of notification is important. We also have to reflect on the fact that enforcement experiences have been insufficient in this regard in Japan. And if the UK actually introduces the data breach notification obligation in the Data Protection Act, the purpose of notification should be clear. I believe it. Finally, we hope to harmonize our different rules and make ongoing efforts to improve the effectiveness of the rules and to make world better and more secure. Thank you for listening to our presentation. And it would be appreciated to give our comments or questions. Thank you.
Thank you. Okay, we do have 2 minutes for questions for Kaori and Taro. So, any questions in the audience?
When do you see international standards such as the ISO? Hi. Where do you see international standards for information security protection, such as, I don't know, is it 2001, or I can't remember which one it is now. So there are certain standards that are used by organizations, so it's not necessarily regulatory, but it's certainly something that's within the organization that sort of prevents these issues with data breach, rather than sort of, this is sort of the habit, this is like, well, it's happened. Where do you see sort of things that organizations could do before that? I can't say, is it 1001? I can't remember. What is the, have you looked at international standards? There is the ITIL, there is the, I can't remember. But yes, there is some.
Do you mean that standards by
so
ISO, something
ISO
like that?
standards, yes, yeah.
Are you familiar with, do you have any comments on that? I think that the data breach notification isn't necessarily included in the ISO. Am I right? Are you talking about
well, it sort of prevents that whole process, yes.
Yeah,
so,
between the, I'm talking about this relationship between the ISO standards and the data breach notification, right?
Yeah.
I'm sorry, I'm not sure about that. But do you have any?
Yeah, absolutely, data breach notification rule should be introduced in as a standard, as international standard. But also, we need legal obligation. As a legal obligation, the data breach notification should be provided in European countries and the United States and Asian countries, because the data leakage can cause similar harm to each individual all over the world.
Yes,
So-
but what I mean is you're looking at it sort of happened, but how do you sort of prevent it from happening? So you haven't looked at that, or is it not really
we
something
can
that-
prevent we can prevent the data leakage.
Okay.
What we have to do is after the data leakage, what we can do is what we are talking about is legal schemes after the data leakage. So, of course, data security, keeping data security can prevent the data leakage. It is one of the options to reduce the risk for the individuals. But the data breach notification is a scheme after data leakage happens.
Of course, the point you mentioned were very important. We recognize it, but we are focusing on the issues of legal schemes after the data leaks occurred, as she mentioned, as she said. So we also think that both of them are important. Yeah, thank you for your question.
Are there any other questions?
I was just wondering, as you compared Japan with UK and US, are you also investigating damages of personal information within other countries, or what was the reason just to use those countries?
He shortcutted the reason for the time.
I was supposed to explain, explain in this presentation, but running because it was running over time, so I skipped the reason. Could I explain briefly the reason why I selected the US and the UK and Japan? In the United States, the US is a country which introduced the right to privacy in the 19th century, the first country, and the massive data leakage has resulted in huge amounts of pecuniary damages. And the enforcement activities of the FTC and data breach notification rules as a legal obligation hold vital lessons for other countries. This is the reason why we selected the United States. The United States is the first country which introduced the right to privacy. Okay. The second, the United Kingdom as an EU member state, because the EU is proud of its advanced data protection capabilities, and finally gave its formal signature to the General Data Protection Regulation on April 27, 2016. Even since the Brexit referendum on June 23rd, the United Kingdom is a country that has experienced enforcement actions regarding violations of the Data Protection Act and stipulated criminal sanctions against unlawful acquisition or disclosure of personal data. That is the reason why we... Okay, speed up. Okay, Japan, we came from also has some experience in addressing data leaks. And there is very little literature written in English that has dealt with issues on data breaches. So we believe that introducing our situation will contribute to future discussion.
Yeah, of course, this reason doesn't follow that the other country is not important. We are making further research and analysis now. So thank you very much for your comments and questions.
Thank Kaori and Taro once again.
Thank you very much.